Good evening, everyone. James Manson here, constitutional lawyer. I'm just coming online to give everybody a quick update about the case that we filed in the federal court. As we all know, it's the prorogation challenge. I'm holding in my hand here the reasons for decision of Chief Justice Crampton. They were just issued a short time ago, about an hour or so ago, which is quite rare on a Saturday. And the reasons relate to the court's determination of the issue of whether this case is urgent and should proceed to an expedited hearing. As many of you may remember, we were asking the court to make that finding by way of a motion that we filed in court last week. The Crown's lawyers got their response into the court on Thursday of last week, and here we are 2 days later with a decision, which is very, very fast, and I compliment and I'm very grateful to the court for their urgency in coming to this conclusion in this reason. So ultimately, I'm pleased to report that the court did find that the case is urgent, and it did set an expedited timetable, which means that we will be hearing this matter on February 13th and 14th of next month. So we will be in court in less than a month to determine whether or not the Prime Minister's prorogation of Parliament was lawful or not. And so there's a timetable in the decision here that sets out the various steps that have to be taken for each party to submit its affidavits and legal briefs and things like that. So I just wanted to maybe read a few paragraphs for those of you who are interested. In my view, they are encouraging. Number one, one of the issues that we were talking about in the motion was whether or not this proceeding is truly urgent, whether or not there's going to be any practical benefit to the case if things drag on until past March 24th, which is the day that Parliament is supposed to be resuming. One of the things that the court said here, I'm reading at paragraph 56, I'll quote you. This is what Justice Crampton said, Chief Justice Crampton said. He said, if the underlying application is not scheduled to be heard on an expedited basis, there will be no opportunity for Canada's elected representatives to debate this serious threat and take any action that they may consider appropriate for over 2 months following President-elect Trump's assumption of office. Next paragraph. The fact that the executive branch of government will continue to function during the period that Parliament is prorogued is beside the point. That's what the Chief Justice has just said. The fact remains that there would be no opportunity for Parliament to carry out its constitutional functions, including by availing itself of legislative tools at its disposal for a significant period during which Canada will likely face a grave challenge. So all of that went to our point that we made to say that, hey, there's a grave threat right now. President-elect Trump is about to take office, and he's threatened to impose a massive tariff on all of our exports. Parliament needs to be in session, was what we were saying. And it seems to me that the court here in these paragraphs was sympathetic to those concerns. There are other interesting passages here. Again, another passage where Chief Justice Crampton says, if Parliament were able to resume its functions for even one of the weeks that it's supposed to be sitting in late February or March, that would provide a meaningful opportunity for it to debate the threatened 25% tariff, pose questions to ministers, and otherwise fulfill its constitutional role. So again, it seems to me that the court is signaling, or at least it understands our argument, which is to say that Parliament needs to be in session so it can at least have some potential impact on the current economic situation. So paragraph 65 is particularly, encouraging for our side. It says, it bears emphasizing that the present circumstances are exceptional and compelling. Enough said. So the decision goes on to talk about other aspects of the motion for urgency, and I won't bore everybody with all the details. I'm sure that we'll be putting the decision online at some point so people can read it for themselves. But anyway, all things considered, I think the decision was naturally encouraging for our side. We were hoping that the court would agree that the case was urgent. The court has now made that determination, so now we will proceed, of course, to the actual hearing of the merits, which will determine whether or not the Prime Minister's decision on January 6th was lawful. It will also determine, from a theoretical point of view, of course, what the limits are. We don't, as I say, we don't know what those limits are in our country, and that's important, I think, for all Canadians and for future prime ministers to understand what are the limits and the scope of their power to prorogue Parliament. When can they do it? When can they not do it? What do they have to demonstrate? What's the reasons? Can it just be for any reason, or does it have to be something more concrete? Anyway, those questions will be left for a different day. Actually, they'll be left for February 13th and 14th. So we'll obviously provide you some further updates. But I'm happy to say that at least today, anyway, our clients did carry the day, and we will be moving forward. So thanks to everybody for keeping in touch, and certainly stay tuned for further updates. Thanks.